I'm going to break this up into several parts because it's hard to keep all these. I got a lot of cases. It's hard to keep them all kind of compact in my brain, and I don't want to lose too much of it. So this is going to be part one. We're dealing with the Georgia arrest of Central, what is it? Central Civilian Auditors News and Information. Ooh, I have comments waiting my review. Yay. I will get to those in a minute. But we are dealing with Legacy Media, who they can't exclude someone simply because they're taking photos. This is an only situation that Billy would be very interested in. I don't believe they trespassed him only because he was taking photos. I think they trespassed him because he was taking photos and being disruptive and some other things, but your mileage may vary. You could do lots of things simply because someone is taking photos. I just want to point out that if you're in the bushes taking photos into someone's private room, you can be trespassed for simply taking photos. Even if you're on, let's say it's a publicly owned park that abuts somebody's private house, and you're standing in the park and you're peering into their window with a camera, that could still be cause to get you trespassed from that place. And before you think you can't, you can. I mean, there's lots of states that can do it, and it's held up. But let's start off. So I'm going to deal with Granted v. City of Rockford and Ward v. Rock against racism first. I'm going to add in Adderley v. Florida and some Georgia Supreme Court cases. And we're going to see why he doesn't actually make the point that he thinks he makes. So Granted v. City of Rockford is where we're going to start. The crucial question, he's quoting, the crucial question is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. Now, the problem with doing these, here's the fun line out of the case, it's going to totally wreck you, is that's a real Mark Stevens kind of approach. You actually have to look at the case. You have to get a feel for what the case is about, so that you could understand what the actual crux of the case is and why the crucial question in City of Rockford was whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. We know what the crucial question is, but we don't know why it's a crucial question. So we're going to start looking at, this is Granted v. City of Rockford. It is a U.S. Supreme Court case. And a great place to start to kind of give you an idea for what a case is all about is the syllabus. That's what the clerks at the Supreme Court, who are very intelligent people, picked out to kind of give you an idea of what you're looking at in this case. And you'll see that they're saying that it's not vague. Well, that's interesting. And it's also not overbroad. It'll say somewhere in here it's not overbroad. Unconstitutionally vague or overbroad. That's what they're looking at. They're not looking at whether the statute is a time, place, or manner restriction or anything like that. They're looking at whether it's vague or overbroad. So part one doesn't really deal with anything in detail. This is just saying that this particular anti-picket statute was unconstitutional on its face. So, but what we're dealing with is the anti-noise ordinance reads in pertinent part as follows: no person, while on public or private grounds adjacent to any building in which a school or any class thereof is in session, shall willfully make or assist in the making of any noise or diversion which disturbs or tends to disturb the peace or good order of such a school session or class thereof. So the first thing that they address is vagueness, and the second thing that they address is overbreadth. And the language that Legacy Media quoted starts here. The crucial question is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. Our cases make clear that in assessing the reasonableness of a regulation, we must weigh heavily the fact that communication is involved. The regulation must be narrowly tailored to further the state's legitimate interest. Access to these streets, sidewalks, parks, and other similar public places for the purposes of exercising the First Amendment rights cannot constitutionally be denied broadly. Free expression must not, under the guise of regulation, be abridged or denied. In light of these general principles, we do not think that Rockford's ordinance is an unconstitutional regulation of activity around a school. So you'll see what they're talking about here is streets, sidewalks, parks, and other similar places. And that might be jogging your old noggin. It might be jogging your noggin. You might be thinking that sounds familiar. Well, we're actually going to read this because I think it might help. And yes, it is long. And I'm going to start at the vagueness portion. This isn't really pertinent to what he was talking about, but vagueness is an important issue. So it is a basic principle of due process that an enactment is void for vagueness if its prohibitions are not clearly defined. Vague laws offend several important values. First, because we assume man is free to steer between lawful and unlawful conduct. We insist that laws give the person of ordinary intelligence a reasonable opportunity to know what is prohibited so that he may act accordingly. Vague laws may trap the innocent by not providing fair warning. Second, if arbitrary and discriminatory enforcement is to be prevented, laws must provide explicit standards for those who apply them. A vague law impermissibly delegates basic policy matters to policemen, judges, and juries for resolution on an ad hoc and subjective basis, with the attendant dangers of arbitrary and discriminatory application. Third, but related, where a vague statute abuts upon sensitive areas of basic First Amendment freedoms, it operates to inhibit the exercise of those freedoms. Uncertain meanings inevitably lead citizens to steer far wide of the unlawful zone than if the boundaries of the forbidden areas were clearly marked. Although the question is close, we must conclude that the anti-noise ordinance is not impermissibly vague. The courts below rejected appellant's arguments that prescribed conduct was not sufficiently specified and that police were given too broad a discretion in determining whether conduct was prescribed. Although it referred to other similar statutes it had recently construed and upheld, the court below did not elaborate on the meaning of the anti-noise ordinance. In this situation, as Mr. Justice Frankfurter put it, we must extrapolate its allowable meaning. Here we are regulated to the words of the ordinance itself, to the interpretations the court below has given to analogous statutes, and, perhaps to some degree, to the interpretation of the statute by those charged with enforcing it. Extrapolation, of course, is a delicate task, for it is not within our power to construe and narrow state laws. With that warning, we find no unconstitutional vagueness in the anti-noise ordinance. Condemned to the use of words, we can never expect mathematical certainty from our language. The words of the Rockford Ordinance are marked by flexibility and reasonable breadth rather than meticulous specificity. But we think it is clear what the ordinance as a whole prohibits. Designed, according to its preamble, for the protection of schools, the ordinance forbids deliberately noisy or diversionary activity that disrupts or is about to disrupt normal school activities. It forbids this willful activity at fixed times, when school is in session, and at sufficiently fixed places, adjacent to the school. Were we left with just words of the ordinance, we might be troubled by the impression of the phrase tends to disturb. However, in Chicago v. Meyer and Chicago v. Gregory, reversed on other grounds, the Supreme Court of Illinois construed a Chicago ordinance prohibiting, inter alia, a diversion tending to disturb the peace, and held that it permitted conviction only where there was imminent threat of violence. Since Meyer was specifically cited in the opinion below, and in turn drew heavily on Gregory, we think it proper to conclude that the Supreme Court of Illinois would interpret the Rockford Ordinance to prohibit only actual or imminent interference with the peace or good order of the school. Although the prohibited quantum of disturbance is not specified in the ordinance, it is apparent from the statute's announced purpose that the measure is whether normal school activity has been or is about to be disrupted. We do not have here a vague, general breach of the peace ordinance, but a statute written specifically for the school context, where the prohibited disturbances are easily measured by their impact on the normal activities of the school. Given this particular context, the ordinance gives fair notice to those to whom it is directed. Although the Rockford Ordinance may not be as precise as the statute we upheld in Cameron v. Johnson, which prohibited picketing in such a manner as to obstruct or reasonably interfere with the free ingress or egress to and from any courthouse, we think that, as in Cameron, the ordinance here clearly delineates its reach in words of common understanding, on which appellant particularly relies, presented completely different. Cox v. Louisiana and Coates v. Cincinnati, on which appellant particularly relies, presented completely different situations. In Cox, a general breach of the peace ordinance had been construed by state courts to mean to agitate, to arouse from a state of repose, to molest, to interrupt, to hinder, or to disquiet. The court correctly concluded that, as construed, the ordinance permitted persons to be punished for merely expressing unpopular views. In Coates, the ordinance punished the sidewalk assembly of 3 or more persons who conduct themselves in a manner annoying to persons passing by. We held, in part, that the ordinance was impermissibly vague because enforcement depended on the completely subjective standard of annoyance. In contrast, Rockford's anti-noise ordinance does not permit punishment for the expression of an unpopular point of view, and it contains no broad invitation to subjective or discriminatory enforcement. Rockford does not claim the broad power to punish all noises and diversions. The vagueness of those terms, by themselves, is dispelled by the ordinance's requirement that 1. The noise or diversion be actually incompatible with normal school activity, 2. There be a demonstrated causality between the disruption that occurs and the noise or diversion, and 3. The acts be willfully done. Undesirables, or their annoying conduct, may not be punished. The ordinance does not permit people to stand on a public sidewalk only at the whim of a police officer. Rather, there must be demonstrated interference with school activities. As always, enforcement requires the exercise of some degree of police judgment, but, as confined, that degree of judgment here is permissible. The Rockford City Council has made the basic policy choice and has given fair warning as to what is prohibited. The ordinance defines boundaries sufficiently distinct for citizens, policemen, juries, and appellate judges. It is not impermissibly vague. Now we're going to talk about overbreadth. A clear and precise enactment may nevertheless be overbroad if, in its reach, it prohibits constitutionally protected conduct. Although appellant does not claim that, as applied to him, the anti-noise ordinance has punished protected expressive activity, he claims that the ordinance is overbroad on its face. Because overbroad laws, like vague ones, deter privileged activity, our cases firmly establish appellant standing to raise an overbreadth challenge. The crucial question, then, is whether the ordinance sweeps within its prohibitions what may not be punished under the First and 14th Amendments. Specifically, appellant contends that the Rockford Ordinance unduly interferes with the First and 14th Amendments' rights to picket on a public sidewalk near a school. We disagree. We're looking at a public sidewalk. In considering the right of a municipality to control the use of public streets for the expression of religious or political views, we start with the words of Mr. Justice Roberts that, whenever the title of streets, or wherever the title of streets and parks may rest, they have immemorially been held in trust for the use of the public and, time out of mind, have been used for purposes of assembly, communicating thought between citizens, and discussing public questions. Hague v. CIO. The right to use a public place for expressive activity may be restricted only for weighty reasons, and these are referring to traditional public forums. Clearly, the government has no power to restrict such activity because of its message. Our cases make equally clear that, however, that reasonable time, place, and manner restrictions, that is the test for a traditional public forum, regulations may be necessary to further significant government interests, are permitted. And this is footnote 30. Cox v. New Hampshire, etc. And 29 was Police Department v. Mosley. Interesting. Where was I? For example, two parades cannot march on the same street simultaneously, and the government may only allow one. A demonstration or parade on a large street during rush hour might put an intolerable burden on essential flow of traffic, and for that reason could be prohibited. If overamplified loudspeakers assault the citizenry, the government may turn them down. Subject to such reasonable regulation, however, peaceful demonstrations in public places, again they're talking about streets, if you notice they were all streets, are protected by the First Amendment. Of course, where demonstrations turn violent, they lose their protected quality as expression under the First Amendment. The nature of a place, the pattern of its normal activities dictate the kinds of regulations of time, place, and manner that are reasonable. Although a silent vigil may not unduly interfere with a public library, making a speech in the reading room almost certainly would. The same speech would be perfectly appropriate in a park. The crucial question is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. For overbreadth. The crucial question as to whether it is overbroad is whether the manner of expression is basically incompatible with the normal activity of a particular place at a particular time. Our cases make very clear that in assessing the reasonableness of a regulation, we must weigh heavily the fact that the communication is involved. The regulation must be narrowly tailored to further the state's legitimate interest. Access to the streets, sidewalks, parks, and other similar public places for the purposes of exercising the First Amendment rights cannot constitutionally be denied broadly. Free expression must not, in the guise of regulation, be abridged or denied. In light of the general principles, we do not think that Rockford's ordinance is an unconstitutional regulation of activity around a school. And then they go on from there. But you see that number one, they were looking at an ordinance that was reaching sidewalks. The question was, it would interfere with First and 14th Amendment rights to picket on a public sidewalk near a school. Hague v. CIO is the granddaddy of the traditional public forum cases. The time, place, and manner restriction and the significant, it is significant, right? I always mix this up. It's got to be compelling in the strict, so it's significant. It's got to be a significant public interest. Where is it? Come on. Give it to me. Yep, significant government interests. That is the test for a traditional public forum. So what Granted v. City of Rockford is talking about is a regulation that will impact a sidewalk, which is a traditional public forum. Ward Rock v. Racism is also about traditional public forums. I'm not going to read the whole thing to you. But in Ward Rock v. Racism, or I'm sorry, Ward v. Rock against Racism, I always say that wrong. They're having a concert. They want to have a concert in the middle of Central Park. The only restriction that the city is putting on it is that you have to use the city's sound equipment. And Rock Against Racism wanted to use their own. And the court looked at it and they applied reasonable time, place, and manner restrictions and a significant government interest. And they found that indeed, in a traditional public forum, such as city streets and parks, that the government can protect you against excessive noise. So again, we are looking at a traditional public forum. Adderley v. Florida is where the government is restricting your rights in a non-public forum. This is the granddaddy of the non-public forum. Nothing in the Constitution of the United States prevents Florida from even-handed enforcement of its general trespass statute against those refusing to obey the sheriff's order to remove themselves from what amounted to be the curtilage of the jailhouse. It is public property. It is owned by the public. You could go on the curtilage of the jailhouse. There was a lawn out front, but they were there protesting. The state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. For this reason, there is no merit to petitioners' argument that they had a constitutional right to stay on the property over jail custodians' objections because the area was chosen for peaceful civil rights demonstration, was only reasonable and was not only reasonable but also particularly appropriate. Such an argument has as its major unarticulated premise the assumption that people who want to propagandize protests or views have a constitutional right to do so whenever and however and wherever they please. That concept of constitutional law was vigorously and forthrightly rejected in two of the cases petitioners rely on, Cox v. Louisiana and the other Cox v. Louisiana. Yes, there are two. We reject it again. The U.S. Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purposes. I know you First Amendment auditors out there, of which I am one, don't like this ruling, but this is real. This is tried, true, and tested. So now we've looked at the U.S. Supreme Court cases that are kind of relevant to the free speechy aspects of it. Now let's look at some Georgia Supreme Court cases. This is State v. Boone. State v. Boone. Boone really wanted to go to the airport. He liked going to the airport. Yeah. Where are we at? Come on. Oh, no. Wait, hold on a second. I'm looking at the wrong one. Was it Alonzo that liked the airport? Let's start with this one. Nope. Was it Stone Mountain that liked the airport? Nope. I closed the one that liked the airport. Oh, gosh, golly. I closed the one that liked the airport. I don't know why I closed it. Not State v. Boone. There we go. Are you the airport? You got to be the airport. Yep. All right. We got us an airport. Yeah, it looks better. All right. So defendant went to the city airport, city property. He was trespassed. They said, you need to GTFO the airport. And where was the particular floor or the Georgia trespass statute? OCGA 16-7-21 B2, criminal trespass at Hartsfield Airport. It is a city airport owned by the city. And he was trespassed from it. He went back again, and they said, you need to GTFO. And he's like, nah, brah. And then they arrested him. And he said, I get to stay because you can't kick me off of city property. You can't kick me off city property. And they cite Adderley v. Florida in here somewhere. Here we go, Adderley v. Florida. First, there was sufficient evidence the defendant knew he was banned from the airport. Second, he was arrested in the CNN Center in the airport, not from one of the main public concourses used to access the boarding areas or MARTA transportation. Defendant's position that access to public areas may never be restricted is not tenable. See Adderley v. Florida. So they said no, the state can. When I say state, I mean city, county, state, that kind of government structure can trespass you in the state of Georgia. This one was an appellate court. That's why I closed it, but whatever. I started talking about it. All right. Now, Stone Mountain Memorial Association. This one is a prayer circle. Yep. All righty. So these guys went to a park, not a prayer circle. Okay. See, I'm getting mixed up. This is why I'm trying to limit it. All right. So this one, a park was saying that you can't distribute, you can't leaflet, except if you give 7 days advance notice, and there's only 2 spots you could do it. Each one of those 2 spots can only accommodate 4 leafleters. And in this, they looked at the park, and as you could probably tell from time out of mind, parks have been traditional public forums, and they're like, no, bro. And they cited Adderley in here. The government was saying that, oh, you know, Adderley says that that we get to preserve the property under its control, but Adderley only works in non-public forums. Won't work on a park. So that was Stone Mountain Memorial Association. So this one's a win, right? Because it is a traditional public forum. Now you've got to be the prayer circle. No, you're not the prayer circle. All right. So this one, a bunch of students broke into the president's office of a university, and they were told the GTFO because they were there for like 2 hours, and the students are like, nah, brah. So they all got arrested. And the fact that the appellants were on a public property at the time they were requested to leave is immaterial. See Adderley v. Florida. It has been held many times, both here and in the United States Supreme Court, that the rights protected by the First Amendment of the United States Constitution, though fundamental, are not absolute and must be tempered to a degree by the concepts of order and healthy respect for the rights of other citizens. The constitutional attacks here made are without merit. And did this one also do great? No, it was the other one. It was the final one that did great. Boom. This is the prayer circle. I keep wanting to go to this one because this is the one that also did yes. All right. So these guys went into the Georgia World Congress Center. It is owned by the state. It is a state-owned building. And they prayed. And just because there's so many of them, they did block the flow of pedestrian traffic. And the trial court, remember we're in the Georgia Supreme Court, but the trial court determined the statute was facially unconstitutional as being vague, overbroad, and imposed prior restraint on free speech, observing that the statute armed security personnel with the authority to determine the subjective intent of a party prior to any act being committed, arms them with the authority to exclude persons if the guard thinks they pose a threat to security or if they are merely displaying banners or placards. These provisions invite discriminatory application and restrict free speech and assembly in violation of the Georgia and United States Constitution. The state contends it was an error to hold the statute unconstitutional. We agree in reverse. So here we're going to see a little bit of Grainid, and a little bit of Adderley. The statute is not so facially overbroad or so vague as to violate First Amendment freedoms of assembly or speech. That sounds familiar, don't it? Its language clearly seeks to prescribe conduct, not free speech, and that conduct, even if expressive, falls within the scope of otherwise valid criminal laws that reflect legitimate state interests in maintaining comprehensive controls over unconstitutionally protected conduct. Or over constitutionally unprotected, yeah, okay. Further, no constitutional infirmity is created by language in the statute authorizing the exclusion of those persons whom a guard, by the exercise of subjective evaluation, determines has the potential of violating the security of personnel or whose activities are intended to disrupt or interfere with the normal activities and functions carried on in the building. Whose activities are intended to disrupt or interfere with the normal activities and functions going on in the building. Language regarding intent is commonly used in statutes regarding conduct. Law enforcement officers must exercise subjective evaluations as part of their duty to protect the public safety, peace, and comfort and convenience from unauthorized conduct. The state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. Adderley v. Florida. The statute sub judice prescribes specific conduct. These restrictions are limited and punish only conduct which disrupts or is about to disrupt normal activities, and etc. So those were the U.S. Supreme Court cases. I didn't do Brown v. Brown v. Texas because it didn't really fit in here yet, and these were the Georgia Supreme Court cases. So I hope that kind of lets you know why Grainid wasn't the rock solid thing that you thought it was, and also why Ward v. Rock against racism wasn't. It is the wrong forum. You're looking at the wrong forum. So there you go. That is that part. There will be more coming, but this will be the end of part 1. Thanks for watching. Have a great day.